revision, appeal. So then we should see what does it mean, revision, 115. Where it says any order or judgment can be challenged before the High Court by way of revision on 3 grounds. Of course, we will not go into discuss in detail. What are those 3 grounds? One is if the order is passed without jurisdiction. First ground. Second ground, if the order has been passed exceeding its jurisdiction. Sorry, failed to exercise the jurisdiction. One without jurisdiction, ಇನ್ನೊಂದು failed to exercise the jurisdiction. Another is perverse order. That means without application of the mind. To give you simple example to make it more clear, an IA has been filed for amendment of plaint, Order 6, Rule 17. So we are all very familiar, that is also amended. Order 6 Rule 17 is also amended on 19/2002. Now we have to seek for the amendment of the pleadings before trial starts. Of course, they have made a provision, even after evidence is also, we can seek for amendment only when the party who wants the amendment should satisfy the court in spite of his due diligence. He could not seek for this proposed amendment. ನಾನು ಎಷ್ಟೇ ಎಚ್ಚರಿಕೆ ವಹಿಸಿದ್ರೂ ಸಹ ಈ ತಿದ್ದುಪಡಿಯನ್ನ ಸಾಕ್ಷಿ ವಿಚಾರಣೆ ಮಾಡೋದಕ್ಕೆ ಅವನು ಕೇಳಕ್ಕಾಗಲಿಲ್ಲ ಅಂತೇಳಿ ಅವನು ಮನದಟ್ಟು ಮಾಡಿಕೊಡ್ಬೇಕು ನ್ಯಾಯಾಲಯಕ್ಕೆ. ಅಂಡ್ ಸಚ್ special case only the court can permit the parties to amend their pleadings after trial starts. Otherwise, only before evidence, the amendments have to be sought carefully. So the court will look into certain grounds, either to allow or dismiss the application for amendment under Order 6 to 17. Whether it is going to change the nature of the case or cause of action, whether any right has been accrued to the opposite side, and most importantly, whether the proposed amendment is required for passing effective and judgment effectively and judiciously. ವ್ಯಾಜ್ಯವನ್ನು ಸಮರ್ಪಕವಾಗಿ ನ್ಯಾಯಸಮ್ಮತವಾಗಿ ತೀರ್ಮಾನ ಮಾಡೋದಕ್ಕೆ ಈ ತಿದ್ದುಪಡಿ ಅವಶ್ಯಕತೆ ಇದೆಯಾ? ಆ ತಿದ್ದುಪಡಿ ಏನಾದರೂ ವ್ಯಾಜ್ಯದ ನೇಚರ್ನ ಬದಲಾಯಿಸುತ್ತಾ, ವ್ಯಾಜ್ಯ ಕಾರಣ ಬದಲಾಯಿಸುತ್ತಾ, ಪ್ರತಿವಾದಿಗೆ ಅಥವಾ ಎದುರುಗಡೆಯವರಿಗೆ ಏನಾದರೂ ಅಧಿಕಾರ ಉಂಟಾಗಿದೆಯಾ, ಅದಕ್ಕೆ ಬಾಧೆಯಾಗುತ್ತಾ? affects his right. Any right has been accrued earlier, will it affect? So these are the few things the court will look into while considering an application for amendment under Order 6 to 17. And most of us fail to see Order 6 to 18, which is also important because it makes mandatory on the part of the person whose application has been allowed to carry out the amendment within 14 days. ಅದರಲ್ಲಿ ಅವರು ಸೀಕ್ ಪರ್ಮಿಷನ್ ಆಫ್ ದ ಕೋರ್ಟ್ 14 ದಿವಸ ಒಳಗಡೆ ನೀವು ತಿದ್ದುಪಡಿ ಮಾಡದೇ ಇದ್ರೆ ನ್ಯಾಯದ ಅನುಮತಿಯನ್ನು ತಗೊಂಡು ಮಾಡಬೇಕಾಗುತ್ತೆ. ಶುಡ್ ಬಿ ವೆರಿ ಕೇರ್ಫುಲ್. ಸೊ ವೆನ್ such an application is made, plaintiff says there is a typographical mistake. Instead of 50,000, that has been mentioned as 15,000. Typographical mistake. He seeks for amendment of that before evidence is in. So now, if the court, after hearing both the sides, dismisses such an application, so naturally we can say that it has failed to exercise the jurisdiction vested in it, because it will not change the nature of the suit. Cause of action of the lawsuit not change. No right has been accrued to the opposite side. So that ground failed to exercise the jurisdiction vested in it. Exceeded its jurisdiction. Another example, a suit for recovery of money has been filed based on promise and note. Now the plaintiff wants to amend his plaint for declaration of title over his immovable property. It is completely a different cause of action. Nature of the suit is also different. If such an application is allowed, definitely we can say the court has exceeded its jurisdiction. ಆ ರೀತಿಯ ತಿದ್ದುಪಡಿಗಳನ್ನ ಅಲೋ ಮಾಡೋದಕ್ಕೆ ವ್ಯಾಪ್ತಿಗೆ ಅಧಿಕಾರ ಇಲ್ಲ. It has exceeded its jurisdiction. Revision can be filed. ಆ ಗ್ರೌಂಡ್ಸ್ನಲ್ಲಿ ಬರುತ್ತೆ. Third ground, the court has not applied its mind. No reasoning, no application of the mind by the presiding officer. Justice says that IF for amendment of plaint is filed. Defendant has filed the statement of objections. Application is dismissed. But you can say purpose. So these are the three grounds. If you make out any one of the grounds, revision can be filed. But it is not sufficient. It further says, section 115, even though you have got one of these grounds in your favor to challenge any order, if such an order is appealable, no question of filing revision. No question of revision. You cannot file revision because it is an appealable order, for which you have to go to section 105 and order 43 of the Code of Civil Procedure, which gives you the details of various orders under which you can file appeal against orders. Normally, an appeal is provided against decrees. Decree is defined in section 2, subsection 2. Expression of the court with regard to dispute or issue adjudicating by virtue of that opinion. That will be termed as a decree. But there are inclusion. Rejection of plaint is also a decree, order 7 to 11. And an order passed under section 144, restitution. But suit dismissed for default, it is not. Any appealable orders, it is not a decree. That's what section 2, subsection 2 says. So difference is, if by virtue of that expression a court passes an order conclusively determining the issue or a case, that becomes a decree. If it does not conclusively determine the rights of the parties but passes an order, it will not be a decree. So only against decree, you can file an appeal under section 96 coupled with order 41 of the Code of Civil Procedure. Otherwise, first you should see whether it is an appealable order or not. Order 43 you should go, or section 105, 104. When you seek for permission to file a suit under section 91 or 92, public nuisance 91, public charities 92, which are required to be filed only after getting the permission of the court. If such a permission is denied, it is an appealable order under Order 43 of the Order 4 of the Code of Procedure. Similarly, in order passed under Order 9, Rule 13, it also an appealable order if it is allowed order. Otherwise, no. Rejecting the application. They have made distinction here. There, in Order 43, you will also find order passed on Order 39, Rule 1 and 2 and Rule 4. It is an appealable order. An application filed for temporary injunction or vacating the order of ex parte temporary injunctions under Order 39, Rule 1 and 2 and vacating under Rule 4 is an appealable order. So next question will be, to which court an appeal has to be filed? Appellate court. Which is that appellate court in civil hierarchy? Because if the value of your suit is below 5 lakhs, the suit will be filed in junior division. Above 5 lakhs, senior division. So naturally, if the order is passed by the junior division on an application, appeal has to be filed before the senior division. But you should also see the provisions of the Karnataka Civil Courts Act. There is another act which gives you the appellate jurisdictions and peculiar jurisdiction of the civil courts, where, as far as I know, if the value of your suit is below 10 lakh, values below 10 lakhs and above 5 lakhs. Up to 5 lakhs, we know, junior division, appeal to senior division. But when you file the suit before the senior division, naturally it will be more than 5 lakhs. If the value is more than 5 lakhs and below 10 lakhs, appeal lies to the district court. Above 10 lakh, direct appeal. So depending upon the value which you have made in your suit, plaint, you should file the caveat under section 148 of the A of the Code of Civil Procedure, anticipating the opposite party filing the appeal against the order on application filed under Order 39, Rule 1 and 2 or 4 of the Code of Civil Procedure. So, when you file the appeals against orders, that will be termed as MA before trial courts, MFA before the High Court. Whereas if you file a regular appeal under section 96 and Order 41, it will be termed as RA before the trial court, RFA before the High Court. So once the caveat is filed, the court is duty bound to issue notice to the caveat and hearing before passing any ex parte interim order. That is the very purpose of filing the caveat. So, when you want to challenge any order decree, first you should see whether this order is amenable to the appeal on Order 4 or Order 43. No. Any 3 grounds are available. As we have seen, the court has failed to exercise the jurisdiction, exceeded its jurisdiction, or is non-application of mind. So these 2 grounds were used to be followed earlier to the amendment to 115 of the Code of Civil Procedure of 1999 and 2002. Now in addition to this, We have got one of the grounds, court has failed to exercise jurisdiction. Can I file a revision against this order? Passed on an application under Order 6 to 17 for amendment. The present amendment to 115 says no. Why? It says, the amendment says, if that order were to be made in favor of the person who is challenging that order, should decide the case, then only you can prefer the revision. ಅಂದ್ರೆ ಈಗ IFR ಅಮೆಂಡ್ಮೆಂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಅದು ಅಲವಾಗಿದ್ರೆ ಕೇಸ್ ತೀರ್ಮಾನ ಆಗಬೇಕಂತ. ಆ ಕೇಸ್ ತೀರ್ಮಾನ ಆಗ್ತಾ ಇತ್ತು ಅಂದ್ರೆ ಮಾತ್ರ ನೀವು ರಿವಿಷನ್ ಹಾಕ್ಬೋದು, ಇಲ್ಲದೆ ಇಲ್ಲ. Virtually it is saying that no revision because in none of the orders, very few orders which we will examine, the case will not be closed, decided. The case will not be decided. Take for example any orders on an application, interim order, order 1 to 10 in pleading, it will not decide any case. Order 26, appointment of commission, it will not decide any case. Order 40, appointment of receiver, that will also not decide any case, either allowing or dismissing. So virtually they have taken away the right of the parties to file a revision. That was the intention also for amending section 115 of the Code of Civil Procedure. The lawmakers have succeeded to the extent of stopping the people from filing the revision. But their intention was not that alone. Their intention was, see, the party should not challenge the interim orders unnecessarily. ಅದು ಅವರ ಮುಖ್ಯ ಉದ್ದೇಶ ಆಗಿದೆ. ತಾತ್ಕಾಲಿಕ ಆದೇಶಗಳನ್ನು ಅವರು ಚಾಲೆಂಜ್ ಮಾಡ್ಕೋಬೇಕು, ಮಾತಾಡ್ತಿದ್ರೆ ನಾವು ರಿವಿಷನ್ ಆಗ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ, ಮಾಡಿ ತೆಗಿಬೇಕು. ಬಟ್ as we all know that purpose has utterly failed. ಏನಾಯ್ತೀಗ, now revision is gone, writ has come. That is all the difference. Revision ಬಂತು, writ ಬಂತು. Writ is more costlier than revision. It does not serve its purpose. So that is how we have to deal. ನಿಮ್ಗೆ ಇನ್ನೊಂದು ಎಕ್ಸಾಂಪಲ್ ಕೊಡಬೇಕಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ, whether 115 under what circumstances will be attracted. I think order 7 to 11. So yesterday we have examined order 7 to 10, return of plaint. Well, one ವಿಷಯ ಹೇಳಿ I will come to order 7 to 11, which I did not deal with. One, the court finds that it has no jurisdiction, territorial or pecuniary jurisdiction, as contended by the defendant in his written statement. It will order for return of the plaint. But if the plaintiff is sure he has made a mistake, or not tappagide, I could not have filed the case in Bangalore, as in the case of yesterday's illustration. If the opposite party has already appeared, defendant has already appeared, because this objection with regard to the jurisdiction can be raised by the office itself, or the court itself can raise before the appearance of the defendant. When it was noticed by the opposite side and he has appeared, then the plaintiff can make use of order 7 to 10 capital A if he is sure that he has made a mistake in filing the case in this particular court. He ought to have filed in a different court, where it says he can make an application under order 7 to 10A, request the court, yes, there is a mistake on my part, please permit me to withdraw the suit, you take back the claim, and I undertake I am going to represent this plaint within 28th of February and represent the same plaint before the City Civil Court, Bombay, before 30th of March. And I request this Honorable Court to fix a date for appearance of both the parties on that day. He has got such a right under Order 7-10 capital A, which is very, very useful to avoid unnecessary time. What happens then? If you make such an application, invariably the court will allow such application and fix the date so that there is no need for the court to which the plaintiff is going to represent the plaintiff to issue a summons. So he can avoid that unnecessary waste of time. ಇಲ್ಲೇ ಕೋರ್ಟು ಸಮಯವನ್ನು ನಿಗದಿ ಮಾಡೋದ್ರಿಂದ ಮತ್ತೆ ಆ ಬಾಂಬೆ ಕೋರ್ಟಿಂದ ನಿಮಗೆ ಸಮನ್ ಬರೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ, ಕೊಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಬಿಕಾಸ್ ಡಿಫೆಂಡೆಂಟ್ ಹ್ಯಾಸ್ ಆಲ್ರೆಡಿ ಅಪಿಯರ್ಡ್. Even Order 7-10B, which also says the same thing, but that option can be exercised by the plaintiff when he challenges the order passed by the trial court dismissing or allowing the application of the defendant. Defendant files application under Order 7-10. Court allows his application. Plaintiff is not happy, he challenges that order in an appeal. So in appeal, again, if the plaintiff sees that yes, I have made a mistake, there also he got a chance under Order 7-10 capital B. Same request he can make. Appellate court also can fix the date. So that is how we have to deal with regard to Order 7-10, return of the plaint. Here itself we will examine the rejection of plaint, which you are examining in the background of 115 division. Earlier only 4 grounds were available to the defendant to seek for rejection of the plaint, provided under Order 7-11. Cause of action, suit is not properly valid and not paid the correct court fees, second ground. Suit is properly valid but deficit court fee has been paid, third. Fourth, suit is barred by any law. Now they have added 2 more grounds in 1999-2000 amendment, where they say that if the plaint is not filed in duplicate, there is 1 more ground for rejection of the plaint. And the last ground is if the plaintiff fails to furnish as many as copies as there are defendants. That is also one of the grounds for rejection of our plaint. You should be very careful. Of course, straight away it will not dismiss or reject the plaint. Court will give time. ತಪ್ಪಾಗಿದೆ rectify ಮಾಡ್ಕೊಳ್ಳಿ. So also in the court fees, you are not properly valued the suit and paid correct court fees, properly valued. ಅಷ್ಟಾಗಿ ಅವ್ರು ಮಾಡದೇ ಇದ್ರೆ court left with no choice except to dismiss, reject the plaint. ಸರಿಯಾಗಿ ವ್ಯಾಲ್ಯೂ ಮಾಡ್ತಾನೆ, 50,000 ಕೋರ್ಟ್ ಫೀಸ್ ಕೊಡಬೇಕು, 25,000 ಕೊಡ್ತಾರೆ. Office will raise an objection, deficit court fees. Court will grant time. In spite of that, if it fails to pay, then court has to reject the plaint. Barred by any law. Earlier cause of action. So if the defendant says there is no cause of action for the plaintiff to file this suit, court will ask the plaintiff, what do you say about his application under Order 7-11A? Or the defendant files an application under D. Suit is barred by law of limitation or barred by Section 68 of the Partnership Act or Section 80 of the Code of Civil Procedure. Suit filed against government, no mandatory notice, statutory notice has been issued before filing of the suit. What do you say? And one more, or so many other grounds are also there, barred by any law. Res judicata. But recently, the Supreme Court has taken the view, and earlier also, as far as limitation and res judicata are concerned, that cannot be entertained in the initial stage of Order 7 Rule 11 because they are mixed question of fact and law. Under Order 14 we will see different types of issues. That is also one of the important topic for the examination issues. So, when it is mixed question of fact and law, you cannot summarily reject the plaint on that ground. It requires recording of evidence, limitation and res judicata. For res judicata, you have to see, was there any earlier suit under Section 11 of the Code of Civil Procedure? All those ingredients of res judicata, same parties or person claiming to the same person, whether the earlier court had the jurisdiction to grant the relief in the second suit which is claimed by the plaintiff. All those things have to be examined by the court. Therefore, the Supreme Court has taken the view latestly in 2021, I think, or 2022. SAR within bracket civil page 1053. Earlier also the Supreme Court has taken the same view. It has reiterated the same principle in this decision. 2021 SAR within bracket civil. SAR stands for Supreme Appeal Reporter, monthly journal. Page 1053. Parties name Rajendra Bajoria and others versus Hemant Kumar Jalan and others. Sir, this is with regard to cause of action. This is with regard to here there is no cause of action. A suit was filed by the partner under the Partnership Act. Then the defendant filed the application. No, the plaintiff has no cause of action to file the suit under the Partnership Act. Under section 42, 43 and 44 of the said Act. Therefore, the plaint has to be rejected. So then the Supreme Court upheld that contention. Trial court upheld. High Court reversed the judgment, holding that no, it will not attract section or 7 to 11A. But Supreme Court said no, he cannot seek such a relief. There is no cause of action for the plaintiff to seek in a Partnership Act, and it set aside the order. But as far as the one which I said, that is reported in 2021 SAR, res judicata. This is 2021 SAR within bracket civil, page 956. SAR civil, page 956. Parties name Shri Hari Hanuman Das Totala, T-O-T-A-L, Totala versus Hemant Mittal Kamath and others. Where the Supreme Court has held that no, that cannot be considered under Order 7 to 11 because it is a mixed question of fact and law. Pleadings have to be considered evidence and earlier decisions, therefore it cannot be under Order 7 to 11. So that is how we have to deal with regard to the rejection of plaint under Order 7 to 11. Now, coming to our point, When such an application is filed,